Good afternoon, everybody. I want to welcome you to our meeting today. I'm Dennis Bazanich with the County Executive Office, and I'll kind of play host and ringleader, whatever, today for the meeting and stuff. We have a lot of folks with us, and the other thing I want you to know about this afternoon, this is the second in a series of informational meetings we've done with the industry. Our goal was to really just have it be industry reps here, so we did not include all of our other friends in this process, and so this is really meant as a time for the industry to get information and ask questions. There is going to be Q&A at the end. We do have some presentations today, but we will have questions at the end. If we can hold those, that would be really helpful. Another piece of housekeeping, if there's anybody in the hearing room in Santa Maria, could you make yourself, wave or come on camera, come up to the podium real quick? Sorry, I hate to make you actually stand up. Oh, good.
There are about, 10 of us.
Oh, 10 of you, okay. Well, great. Well, thank you. Welcome for the folks in Santa Maria. We appreciate you being here. We're going to get started. I think you can see us on the screen there. We also had the agenda up. So here's the last piece of housekeeping for today is we have to be out of here done at 4:30. We've got a hard stop. There's a poetry contest in here tonight, and I don't want kids who have to recite poetry to be nervous, because I would be nervous enough if I had to recite poetry. So that would pretty much be the end of my life. So at this point, just to go through the agenda real quick, we've got Kevin Ponce here from California Department of Food and Agriculture from Cal Cannabis. Kevin's in the back of the room. We'll bring him up in just a moment. Also with us today from EED is Francisco. He's here to talk really about your requirements for withholding taxes and how you're going to pay taxes and all that kind of stuff for your employees. This is about your employee withholding taxes, okay? Not the county's taxes, but employee withholding taxes. And then the last presentation we're going to have today is Ed Blanco's here from the Agricultural Labor Relations Board. And most of you are aware in the state regs, there's a requirement for either an agreement to establish a labor peace agreement or to have a labor peace agreement. But Ed told me some things that the other day that he just thought, regardless of where you are in that process, there's some things you ought to know now. And so I said, Ed, if you could come talk, I think that'd be really, really good around labor organizing efforts and stuff for your workers. Some good warnings there. So, and then we'll do some county updates right at the end. And then, as I say, my hope is really to leave the bulk of the time at the end for asking questions. So hopefully we'll go fast. So at this point, what I'd like to do is ask Kevin, if you don't mind coming up, get us started with your presentation today, and I'll switch over to your PowerPoint.
Good afternoon, everybody. My name is Kevin. I'm the Senior Supervising Environmental Scientist for California Department of Food and Agriculture, Cal Cannabis Licensing Program. I'm here today to speak a little bit on just the overall process that we go through when we review applications, and fill you in on a little bit information on provisional licenses, the difference between those and annuals, and provide you some information on CCT, or the track and trace system metric, and how that pertains to provisional licenses as well. And I'm pretty sure everybody at this point knows this, so we'll just skip on right past that. This is just a little informational blurb about who does what. As you may or may not realize, there's the BCC and the California Department of Public Health, and we're all sister agencies. We all engage in separate licensing activities for separate components of the cannabis industry. CDFA does cultivation. Cal Cannabis, within Cal Cannabis, there's three branches. There's the licensing branch, which I belong to, compliance and enforcement. Those are the guys that come around and do inspections, site visits, that sort of stuff. And then we have an administrative branch within the division as well. This is just a pretty basic graphic on what your application goes through when you submit it. So it's received. The first step is local verification. So our staff reaches out to the city or county officials, wherever it is that you have stated that your cultivation site is. There's two parts to that. There's a 30-day period in which the locals can get back to us and say yes or no, these people are compliant. If they don't get back to us, it's a 60-day period. If we don't hear from them in 60 days, we proceed as if they had given their compliance. After that is the admin review, and I'll go over a little bit more of these review periods in depth. After the admin review is the scientific review, which I am a supervisor of, and then finally, hopefully, the license is issued. So provisional licenses, the main thing that I wanted to point out about provisionals is they have all the required components of the annual license. So all the regs as they pertain to receiving an annual license, same thing for provisionals, with one exception. You must be able to show that you have CEQA compliance underway, so you don't actually have to have proof of CEQA compliance for a provisional, but you do have to have held or currently hold a temporary license. Forms of local verification, they run the gamut. They're kind of across the board depending on where you are cultivating, but they're location specific. And what we have seen is affidavits from the county or city stating, such and such cultivator is approved to cultivate. They're in the system, CEQA underway, whatever terms they decide to use. Permission letters, emails. We use lists that the city or the county provides us that says, these people are considered in the process, and we will go off of those lists as well. Another big point, provisional is not a separate application. CDFA determines provisional or annual through the review process of your application. That's one of the reasons why we will reach out to people. I don't know how far along you guys are in the process of receiving your license, but when it gets to us, we will reach out and we will ask you for proof of CEQA compliance. Even if what you've submitted may qualify you for provisional, there's so much stuff going on out there. Like, we would hate to issue a provisional to somebody who really deserved to get an annual. So we're kind of doing our due diligence, reaching out, regardless of what it is that you submitted, and just asking. I mean, unless it's a slam dunk CEQA document or something, then that's obviously an annual. But so you'll definitely, most likely, get a email from us asking for clarification on the document that you submitted. This is just a little bit about the local verification. They validate the address, typically using APN, web-based search software. And I already mentioned the compliance inquiry, and I'm sorry, I said 30 days, it's 10, it is 30 days. I gave this talk during temporary time, so there might be a little couple of things slipped in there, but basically you have 10 days to respond. If you don't respond, like I said, you have a 60-day period in which after the 60 days, then we proceed as if the applicant was in compliance. And then they just, those guys, the local verification unit, that's what they do. They analyze the responses and then they send the application on down the line. Go ahead. Admin review, that's where they do all the fun stuff like business entity structure, right to occupy, owner applications, deficient. One thing actually I do want to point out is in the admin section, there's also a 90-day deficiency period. So if you're missing any of these or the document isn't sufficient, the admin group will also send out an email to you saying, hey, your application is deficient. You have 90 days to respond. If you don't respond in those 90 days, your application will be disqualified. So I highly recommend, if you've submitted an application and it's taken a long time and you haven't heard anything, definitely go into your filters, shoot us an email, ask us what's going on. A lot of times what we see is in people's applications, they'll put down an email address as their primary contact. But for whatever reason, they don't really use it all that much, or there's all sorts of reasons out there, but email gets not noticed. And because they put that down as their primary point of contact, we're sort of bound to use that contact. So be very diligent about checking your emails and responding. because that's already happened to a few people, unfortunately. Anyway, yeah, so that's the admin review part. I'm not in the admin section, so I can't speak like a whole lot to what goes on there beyond these little blurbs. But if you have any specific questions, feel free to ask me. Scientific review, so this is where me and my staff live. The big thing is the cultivation plan. And within the cultivation plan, you have your premises diagrams and your property diagrams. These are by far the biggest reasons for deficiencies in applications. I know it may seem rinky-dinky, but when they ask you for dimensions of everything, they mean everything. And that has to be on that premises diagram, or we're gonna shoot you back a email saying, hey, I know you showed the room, but you didn't put the dimensions, kind of thing. So be very diligent about that. Water source, associated documentation, so state water boards, Department of Water Resources, if you're on a well, you need not a county well log, a state well log. So in order to do that, if all you have is a county, you contact Department of Water Resources, you tell them what's going on. They will either issue you a well log from the county or a letter saying that there isn't one available. Lake or stream bed alteration agreement. I'm not super familiar with how that affects everybody down here. I know up north this is a huge deal, partially because of the proximity to fin fish streams, which is a big deal. Yeah, so this can take a long, long time. This can take a real long time. This can take people years to get through. So my recommendation, if you haven't started it yet, do it. Contact Fish and Wildlife.
What are people going to do, because the regs actually say that you have to either turn in a notice saying you don't need an LSAA, or you have to turn in the LSAA to have a complete application, and like you say, it takes years. Most of these people's temps are running out in the next 2 months. What's the state planning to do?
So there's various things in the work. Obviously until they're blessed by the powers that be, I can't necessarily speak on them, but we are aware of the issues with this. Part of the things that we're thinking of is maybe allowing not a full LSA, some sort of some sort of proof, sort of in line with the provisional license requirements. But until those are fully figured out, So unfortunately, unless you have the documents that the regs require, as an agency, we can't really issue you a license. So I think we're going to get through this before we answer the question.
We have temporaries expiring.
So can we just hold the questions till the end? Sorry, I wanted to be able to finish because there may be answers on the next slide.
CEQA compliance, this is, at this point in the review process, is where the decision is made whether or not you're issued a provisional or an annual license. So again, that's why we're going to reach out to you, even if you've submitted what you think is a full, CEQA document. And we've been in the talks with a lot of local cities and counties to really hone in on what it is that they can provide the applicant, that the applicant can then just provide us, because right now it's a lot of third-person kind of conversations. We'll call up the county and say, hey, is this person good to go? And they're like, yeah. So we're really trying to streamline it so you guys can have that document in hand that you just provide in your application. We know that it's good because we've talked with the county or the city, and it just kind of moves on through. Again, 90-day deficiencies for a scientific review. Already talked about that, so go ahead. So California Track and Trace. This is a different department within our unit, so I'm not an expert on this, but I can speak to it a little bit. Basically what it is you're required to report the disposition of immature and mature plants, non-manufactured products, transfer and waste. They like to term it seed to sale, makes sense. If you don't know, they're radio encrypted devices. You use a handy dandy little scanning gun. You can stand in a door and read everything with one swoop. So they're pretty neat to use. And they're provided at no additional cost to the licensee because they're actually figured into your application fee or your license fee. Temporary licenses will not use track and trace. They are required to use shipping manifests to show movement of product, manual documentation. And this transfer documentation needs to be made available at any time for state regulatory agencies as they come through. Annual licenses and provisional licensees will be required to use track and trace. There are no differences in between annual and provisional license for how you use it. It's the same thing. Once you pay for your application, you'll receive a notice telling you to sign up. Once you register and take the course, well, you have 5 days, actually, I'm sorry. 5 days to register after you pay, you'll get an email. Once you register and take the course, you're gonna have 30 days after you receive the tags to attach them. And basically, the way this is gonna work is if you have anything in the ground, your tags are gonna need to be attached to them, mature plants. You're gonna need to attach them to the immature plants if you have any immature plants in lots. And if you're kind of in between, if you've harvested product that's just kind of sitting around, well, the next opportunity for you to enter them into the flow is during the packaging phase. And this is all contained in the track and trace regulations. And I have a actually pretty handy dandy little track and trace fact sheet up there. So those are the main time frames that you have to deal with. And this is just, well, I think there's supposed to be links there, but that doesn't really come through on PowerPoint. So there's a bunch of user guides available, and these are some good contacts for you if you are interested. These people can answer all your track and trace questions, and like I said, there's a whole host of user guides and FAQs that are available. If you haven't yet, go to the website, Cannabis. It's not the most user-friendly website, but it has a ton of stuff on there. A lot of really good, my team's been working hard on putting together reference documents on how to put together your premises diagram, your property diagram, what sort of water documents you need, all that kind of stuff. There's links to all of that there. And I think we're getting pretty close here. Next slide. Yeah, so thank you for joining us. That's the website down there at the bottom. And that number, the 1833, the CalGrow, will get you anywhere in Cal Cannabis. You'll have to go through a series of prompts, but if you have questions about anything, I highly recommend you call prior to submitting a license. We are there to answer your questions. I like to think we do a pretty good job. You guys may think differently, but that's what we're there to do. So, and I think, yeah, well, there we go. And I think that's it. So, any questions? And you had yours.
You're talking about timing of this announcement for the SL and LSA. I mean, there's temporary licenses that are expiring. So
I would hope, that if you hold a temp, you would already be engaged in the process to get a lake and stream bed alteration agreement, lake or stream bed alteration agreement. Like I said, it's kind of an unknown. So if there has been any kind of interaction with the Department of Fish and Wildlife that is verifiable, we may be in a position to work with you, but it's very case specific, kind of where are you in the process, what do you have as proof of your interaction. If you haven't engaged in the process yet, then there's really nothing that we can do for you.
I applied originally under for a temporary license for a small specimen cottage, but mainly applied to the county for a type QB cultivation site, and that's in the process with the county right now. So how am I transitioning on that? Because I'm getting notices to provide information on the site that I'm really not going to be using.
So you have a temporary for a site that you're not going to be growing, that you're not going to be using.
Physical structure on the site is going to be.
We can't hear the questions being asked.
Sorry, I'll play Phil Donahue now and run around with the microphone.
Yes.
So people in the room have to know
To recap, I originally applied for a temporary license for a small specialty cottage operation, but immediately turned around and applied for a much larger operation on the site. And that land use permit is pending with the county. And so I'm in this limbo between the temporary license and the new one.
So, as long as you're in the same location, same APN, same property, and as long as the cultivation type is the same, so, you know, you're not going from nursery to medium or something like that, or processor to cultivation, you would just, have you already applied for an annual?
No.
So you would just apply for the annual that you want?
No.
And that temp license, as long as you link it when you apply, will enable you to get a provisional license.
Well, I am so close to hopefully getting my land use permit.
Okay. We gotta keep moving, so.
All right, I'm so close to getting my land use permit, I may abandon that license.
So here, let me make it real simple. So if you had any kind of thing on your temp, your annual is gonna have to meet what you've applied for your land use permit with the county for. Those have to match. So you're gonna, you have to have that in order to get a provisional, period. Okay, you gotta have an app in. So who's next?
Two questions. First is, what triggers the start date for the either the 30-day or the 60-day local authorization response? Is it the actual submission of the annual
When we email out.
from science?
No, from admin.
Here. So let me make sure. Here, ask your second question.
Cheers. And then the second question is, if you did file for your annual and you end up receiving the provisional annual, is that also going to trigger your annual fees?
Okay, first question is, so basically the 30 or 60 day, and actually I think it's 10, not 30, sorry, response from the locals, that happens as soon as the local verification unit from Cannabis sends out an email. That's the first thing that happens, but it's not when you submit it. So there could be a lag between, I don't know, I don't really know, it depends on if you submit it on a Friday in the afternoon and nobody's there kind of thing.
The microphone is not working.
Is it working now? Can you hear it now? Check it with Sam.
You have a special touch. Unfortunately, the state does not.
Keep the microphone. Here we go.
Hey, I'm sorry, what was that?
For my annual, I filed months ago.
Yeah.
So the local authorization was sent in months ago, so what triggers the start of those periods? My application being submitted.
Right behind you. So I think you're going to have to call Cannabis.
Yeah.
Call them up.
So
Call at the number that's up there.
it
Call
kind of
'em.
depends. There's all sorts
Yeah.
of reasons why it would have been held up. If your local didn't respond, it could have taken 60 days, 60 business days, which can turn into an awfully long time. And then admin, if they had any deficiencies, I would call and ask what's up with my application.
So it started. So the sciencing starts over again. So
Yeah.
you got time again.
Yes.
There you
yes.
go.
Yeah.
All right.
So now you're in a new 90-day period. Yeah.
Provisional trigger annual cost.
Wait a minute. You keep asking questions.
That's the same question. Number two is, does the provision
It's the same cost.
trigger the 40, like let's say a one license fee on the state side, does that trigger the annual cost?
Yeah, I mean,
Temporary is free.
yeah, the provisional costs the same as an annual.
It's in regular form.
Yeah. Yeah.
Sorry, totally naive here, but is there a way to get into the provisional status without a temporary license?
Currently, according to the law, no.
I like those answers. Okay. Here we go.
So I'm to understand that the provisional license once it's given, you owe the annual licensing fee over and above what the application fee was
Yes.
at that time? Okay, and then second is, just want to clarify, the provisional license licensees are need to be part of the CCTT system?
Yes.
Great, thank you.
Okay, any other questions?
If you're going through the CUP process and you want to get your provisional, do you have to have a business permit from a local authorization or not?
It depends on the local jurisdiction. If we contact them and say, is this person considered engaged in the process, and they say yes, regardless of what document you have, then we would issue a provisional.
And I was going to save this for the end, but what the discussion we had last Friday with the state was that we as the county will provide them every single week a list of everybody that's in a CELA that has submitted a permit to our planning and development department. That list is getting sent to the state, and if your name's on that list, bingo, that's qualifying as CEQA underway.
Yeah.
Period. Okay? All right, Santa Maria, questions? Go ahead and just queue up, and we'll try to do these as fast as we can. If you have questions in Santa Maria. By the way, thanks for being there. Thanks for persevering with our technology.
We appreciate the opportunity to ask questions. Unfortunately, we don't have any. Thank you.
Okay, all right. Kevin, thank you. He's going to hang around here. We appreciate it. So next, I'd like to bring up Francisco, who's going to talk about employee withholding taxes.
Thank you.
Probably have to really talk into it.
All right. Does anyone here have employees or any workers, independent contractors, have a company set up already? Okay. So from EDD, I am from the payroll tax branch. So what we do is we collect payroll taxes. That's everything from unemployment, ETT, state disability, and payroll income tax. So once a company pays wages in excess of $100, they become a subject employer and must register with the EDD. They have 15 days to register with the department and report workers. In the folders that I provided everyone, if you guys want to go through that, I gave everyone information sheets about who is an employer, who is an employee, what's constituted as wages, what wages are taxable, and what are they taxable for. What I also included are information sheets on family employment, statutory employees. For example, if you have a corporation, you're a corporate officer performing services. By statute, you should be an employee receiving a wage. I also provided casual labor information sheets. If someone is working for a day, 2 days, a couple of hours, maybe 2 weeks, they're on probation period, they don't pass probation period, that is considered to be casual labor, and they are still considered to report wages for that worker. If anyone still isn't registered with the department and they are a company, they have workers performing services, I included a registration sheet. It's called a DE1. You can fill that out, send it up to the Sacramento office, or you can do it online and be registered, and they will assign an EDD account number so you can begin reporting wages for workers. And how you do that is you do that by quarterly returns. So each year you have to file 4, quarter 1, 2, 3, and 4. They have due dates. They range from January through March 31st. That's first quarter. That is due in April. Second quarter is April, May, and June. That's due the next month. The next month's July, August, September. Those are due the following month. And the last month is October, November, December. With those, you have to file and report all the workers and pay payroll tax. I understand that right now, cannabis industry, some of them may not have bank accounts. So a lot of it is cash. You are able to pay workers cash, and you can pay the payroll tax cash. However, the only office closest to Santa Barbara is in Van Nuys. So if you want to pay your payroll tax, I advise that you contact the Van Nuys office and arrange plans to go and pay the payroll tax. That way someone is there. We have staff that's actually able to count the money and go to a bank. They have a designated bank that will accept those deposits. Now, filing electronically is easy, and I also provided information sheets in regards to that in the folder. Beginning January 1st, 2017, AB 1245 passed and requires all employers to file electronically if they have 10 or more workers. Beginning in 2018, January 1st, every employer is required to file electronically, and there will be penalties if they don't file electronically. So please, I advise you, if you already have an account, to file electronically if you're not already doing so. Also, there is a flyer in regards to the cannabis industry and just another flyer that goes over some quick information, and I have information sheets that I mentioned in there. And also, we do have a seminar happening here in Santa Barbara next week, Thursday, the 21st. It's from 9 to 3:30, and that goes over the classification of workers. So if any of the companies have workers already, we go over the classification of them. Are they employees or the independent contractors? And we go over the factors on how to determine whether someone's an employee or independent contractor. And I advise you guys, if you guys have workers and you don't know if you're treating them correctly as employees and independent contractors, please attend that. It is important that they are classified correctly to avoid future penalties, future audits, and just saves you guys lots of money by doing so. Do you guys have any questions as of right now?
So, yeah, so I have one real quick. Yeah. Oh, and let me ask a real quick question. So you said Van Nuys was the closest location for Santa Barbara. Is there one going northbound up the 101 towards SLO or anything else that's available for those payments?
We have a Fresno office. I'm not sure if they are taking payments right now.
Okay. All right. Thank you. All right. Let's go real quick. Sorry, Art, just real quick. We'll go up to North County.
The speaker referenced flyers, handouts, but there isn't anything here. I was wondering how that information might be made available to us.
We tried shoving them through the microphone. It didn't work. So what I'm going to do, both for the slides that Kevin presented, as well as for the material that Francisco's doing, I'm going to mail it out to the entire invite list for this event.
Okay, and then my second question was, you mentioned a workshop on the 21st. Can you say the date, time, and location of that again, please?
Yes, that is actually, let me get that exact address for you. So that's Thursday, February 21st, 9 to 3:30 p.m. That's at the America's Job Center of California here in Santa Barbara, 130 East Ortega Street. Now, I do have electronic copies of a lot of these files, so if you have an email, I can send those over to you as much as I can. Also, that flyer for the seminar, they do have to register for it. But as I said, it is very important that the workers are classified correctly, and it is very informational. Also, DLSC is going to be there, so it goes over Department of Labor regulations in regards to meals, breaks, etc. So not only us, but DLLC will be there. A couple of hours long, but it's very informational.
Great. Any other questions from Santa Maria?
No, thank you.
Okay, great. Thanks. Thanks for being the facilitator there. You know, checks in the mail. Questions here?
So in the past, we've used a labor company to come out and help us out with the work and the labor on the farm. How do we vet the fact that they're actually contributing to this tax process, and do we have any other liability outside of using that particular service?
Now, is it a...
Sorry, second question is, can I get the number to that bank that you deposit that cash into?
I will ask the Van Nuys office, and I will ask the manager in the Van Nuys office. We have an office in Ventura. However, that's a satellite office close to the public, but we are part of the Van Nuys office. So I will contact the manager, and I will ask her for information. Now, to answer your first question, is it a temp agency that provides labor workers for you? Right. Okay, so usually those temp agencies, that's what we call a third party that's involved. We go into that a little bit more in the seminar, but typically either you are the employer of those workers or the temp agency. Now, how we determine that is the factors, the common law factors, and the right to direct and control the workers. They provide workers for you. That's actually a specific code section, 607.5. You can look it up. So it asks 5 questions, and then those answers to the 5 questions will actually determine who's the proper employer. And then whoever the proper employer is, they will have to pay the payroll tax.
Any other questions? Okay, thanks very much, Francisco, and you'll hang out too. Next, I'd like to bring up Ed Blanco from the Agricultural Labor Relations Board. If you.
Good afternoon, everyone. First, I want to thank the county and Mr. Bozanich for this opportunity to speak with you all today. So I am an attorney with the Agricultural Labor Relations Board. I've been with them going on 39 years. I retired a few years ago, and one of the reasons they asked me to come back was to be the front person to speak with you all around the state, to try to educate you about the requirements of the labor law and what you have to do in order to stay compliant. So, and that's what I've been doing for the last 2 years, up and down the state, from the Triangle all the way down to San Diego. And one of the things that's important to remember is that both CDFA and BCC require that you all, whether you're cultivators or any other part of the industry, you all be in compliance with the labor standards of the state of California. And those labor standards are the rules that EDD, ALRB, Cal OSHA, Labor Commissioner, Labor Standards Enforcement, Workers' Comp, those are the rules that are considered the labor standards of the state. So if you violate the labor standards, it may have an impact on your license, all the way up to you losing your license. So, so that's something why you want to know these rules, why you want to be in compliance with these rules. You've worked a long time to get your local license, to get your state temporary license, in the process of having a provisional license, and finally getting your annual license. We don't want you to have used all that time and then wind up with losing it because you violated these labor standards. And I know you don't want that to happen either. So we're committed to working with local jurisdictions like the county and others around the state to provide you a workshop like EDD and DLSE are going to be doing in order to share more in-depth information, a deeper dive into what we do. And I also have to say that for those of you who are not cultivators, many of the rules that apply from us also are the same as the ones that the National Labor Relations Board applies to the rest of the industry. We differ in some very significant ways, and if I have a chance, I'll mention that as I go along. But in certain ways, we're very much the same. So, so those of you who are not cultivators, the information I'm talking about here also pretty much applies to you as well. So we want to give you that roadmap. We want you to be in compliance. We want you to stay compliant with the labor law. And for us, what is the labor law the ALRB enforces? Well, first let me say that each agency that does enforce rules about employment and labor law, we're all pieces of a pie. We kind of all overlap with each other, but we have our individual slices as well. And but what we do specifically is we protect the rights of employees to organize, to speak to union organizers, to want to be represented by a union, to seek to have us hold an election for them to determine whether or not they want to have a union represent them in collective bargaining. And we also protect employees when they want to speak up about the labor standards, when they want to speak about the conditions of the job. For instance, if the workers can get together, come to you and say, hey, the law requires you to provide us drinking water. You're not doing that. We'd like you to do so. Now that's them talking to you about a job condition. You cannot retaliate against them for doing that, as has happened often in other parts of the agricultural industry. Employers sometimes take exceptions for employees speaking up on their own and deal with them harshly. And by firing them, by otherwise disciplining them. An interesting concept is that the idea of what is firing is a broad one. So if a worker comes up to you and makes that particular place else. Now, a lot of folks may not think that's saying you're fired, but the law is very clear, and there's a lot of circumstances in which that does mean that. And it comes down to what does a reasonable employee interpret what you're saying to mean. And many times, the case law is very full of cases where employees have made that determination that you're telling them that you're fired, and therefore you're committing an unfair labor practice. So you want to be careful about those kind of things. Besides protecting employees from retaliation on these various topics, we also, as I mentioned, hold union elections. If the union comes to us, files a petition saying, here we have all these names of employees that want to support us, now we want you to go forward and hold an election. We have to hold that election within 7 days of that petition being filed. And that's one of the areas where we differ from the national board. It could take up to 6 months for them to hold an election. And, but for us, it's very compressed timeline. Within 48 hours of them filing that petition, we need from you employers the list of your employees, their names, their job classifications, and their home addresses. Now, home addresses does not mean a P.O. box. It does not mean a private mailbox. It doesn't mean their address in Mexico. It doesn't mean their address in Bulgaria, Romania, wherever else employees may come from. It means the physical address where they're living now when they come to work for you. So you want to make sure, I think, as a best practice to have that information from the get-go when you hire somebody. Now you're going to get some, at this meeting they're going to have next week, you're going to get some information about the difference between an independent contractor and an employee. But I think for us it's much more simple because it's in our statute. Anybody who's actually doing the physical work in cultivation, our law says is an employee. There is no argument to be made about, for us, there is no argument to be made to us about whether or not they are employees, as opposed to an independent contractor. Now you have many folks, if you've been in cultivation in cannabis or any other part of the industry for a long time, you have many folks who have worked for you for a while. And from the past, you've given them 1099s, and probably for the most part, they've wanted 1099s from you. Mainly because on their end of things, they don't want to pay the income taxes themselves that they would owe for their salaries. But you have to get that out of your heads now. Even if they want a 1099, you can't give it to them. And I think EDD and labor standards will talk to you more about that because that basically pertains more to them. But there's a change of culture and a change of mind that not only is at your end, but it's also at the end of the employees as well. So that's something else you need to remember as you go down that road. Now, if you're a cultivator, let me put it this way. Anybody who gets a cultivation license from CDFA, you're under our jurisdiction. In your annual license, and as you heard from Kevin, in your provisional license, you're going to have to check off a box on your application that says you attest that you are an agricultural employer under the Agricultural Labor Relations Act. And that pretty much means that you're under our jurisdiction. Whether or not you're a nursery, you're a cultivator, or you're a trimmer. All of those are defined under MCRSA as cultivation. So you're going to have that license, and you're going to be under our jurisdiction. Now, there are times when a trimmer may not be under our jurisdiction. And when we do the seminar later on, we'll do a deeper dive into when that is, and I can explain that to you then. I think a lot of you want to know about labor peace agreements. And the thing about that is, oftentimes when I go to NCIA events, CCIA events, CGA events, I hear employers talk about how they reached out to a particular union because they liked that union and they wanted to partner with them. They think they could work with them. And I hear them say that over the microphone. I hear them say that in social media, and I hear them say that on regular media. And they're making a big mistake when they do that. Because if another union hears you say that, you basically walked yourself into an unfair labor practice because you cannot show favoritism to one union as opposed to another. And also, if it's not the other union that hears you say that, if you say that to your employees, you're also potentially walking into an unfair labor practice because to them, you're basically telling them, this is the union I want you to support. And that also is an unfair labor practice because you cannot get into the relationship between them and the union. That's up to them and the union. You have to stay neutral. And if you don't stay neutral, you're walking into, again, a violation of labor standards, and that can have some, as I said, some serious consequences for you. With respect to record retention, as I said, you have to have these documents for us. And oftentimes we hire a contractor, and I heard somebody talk about that a little earlier. In agriculture, the Department of Labor Standards Enforcement requires that anybody who provides you labor for cultivation purposes has to have a farm labor contractor license. If they do not have that farm labor contractor license, you're violating labor standards enforcement rules. So if you're hiring some temp agency to provide you labor, you need to make sure they have that license. Because if they don't, you're already in violation. So what you need to do is demand from them, ask them, and if they're kind of hem and haw about it, demand it from them to see that license. If they don't want to show it to you, you can also go to the Labor Standards Enforcement website, and you can check the list of licensees there to see if their name is on it. But if they're not on there, then I would quickly and quietly find yourself a licensed farm labor contractor and to take that person's spot. Because if it comes out that you've hired this person, you're going to be liable with respect to fines and penalties. And again, that's something that could wind up costing you big time when it comes to your state license. So I think pretty much that's all I would need to say today. I hope, as we go down the road, we'll be working with Dennis. We'll be putting on something bigger that's going to include some of the other agencies, probably again EDDD, probably DLSE, Workers' Comp, Cal OSHA. We'll all be working together as we go forward to make sure that this industry gets all the information it needs to be able to succeed, to be able to comply with local laws, rules, and the state rules as well. So, thank you.
Great, thanks very much, Ed. Let me check with North County first if there's any questions for Ed.
No, thank you.
Great, thank you very much. How about here in this room? Ed, don't go too far, see? There we go, here we go.
Two questions. You said if you're hiring a contractor, they need to have a farm labor contractor license. Is there a specific farm labor license that if you have your own employees that you need to have? I know you're attesting to being an agricultural employer, but...
Right, so if you're hiring direct, if you're hiring your own employees to work for you directly, then you don't need that license. It's only when you're using a third party to provide you the labor that they have to have that license.
But there's specific rules that are different for farm labor that you need to be following?
There are specific rules that a farm labor contractor has to follow
that
are a little bit separate from what you as a direct employer would have to follow.
Okay, and where can we find out about these workshops that you're talking about? Is there a place that they're
Not
listed
yet.
or they're, okay, they have, they're.
We're in the process of having meetings at the hierarchical level between the agencies as to how we're going to be doing this. That's taking place probably with the rest of this month and going into next month. And then after that point, we'll be reaching out, giving dates and stuff, and working, like with Dennis and others to figure out when and where we do these things. But my thinking is probably no sooner than May. So. Yeah, and I'll be giving information to Dennis, and hopefully he'll be linking that and other information that we have for employers that goes a little bit more in depth about things. So.
Tell me, do you have a handout that has the website where you can go and look up someone's farm labor contractor license?
Okay, so I will give that information to Dennis as well. But if you go to the Department of Industrial Relations website, so that's dar.ca.gov, then you're going to scroll down to the section of Department of Labor Standards Enforcement, and in that, scroll down in there, there's going to be some link in there about farm labor contractor licensing. And then when you get in there, then you're going to try to find the list. But we'll try to give you some more direction, like more specifics, et cetera, when we give that information to Dennis.
What was the abbreviation for that site?
So first off, it's dir.ca.gov.
Very good. Thank you.
Sure.
Any other questions for Ed? Okay. Ed, we really appreciate you coming and your willingness to do a more in-depth workshop later on. That'd be really, really key. So thanks a lot. Thank you very much. Next, I'd like to go to Jeff Wilson from our Planning and Development Department to start with our county updates. So Jeff, and this is on the permitting side of the house. Local.
Again, my name is Jeff Wilson. I'm the Deputy Director of the Development Review Division at the Planning Department. With me today is Petra Leva, who's our supervising planner. She's leading the cannabis permitting team. So if you have any project-specific questions today, I recommend I'm reaching out to Petra and having her walk you through any project-specific things. But just a quick update as far as where we're at. We've went through a round of recruitments, and so we actually have our team put together. We actually have 2 full-time staff doing permitting in South County, and we have 1 stationed in North County. That's all they're doing is permitting the cannabis applications. In addition, we haven't changed yet as far as we are still taking all applications down here in Santa Barbara. I know that's a pleasant drive for everybody in the rain. I do it every day, so I feel that commute with you. However, just because of the way we've set things up, you are still required to come down here to submit your applications. However, we're looking at options of how to maybe alleviate that as far as utilizing our North County office. But as far as right now, we still encourage everybody to come down here to actually submit your applications and pay your fees. But the planner in North County, for the most part, she's getting all the applications that are site-specific in the North County area, so it kind of puts a local resource for you as you're working through that process. However, because there's only 3 full-time planners working on it, so there will be some that are assigned down here to work in North County. One of the things that I just encourage everybody to work with our staff, one of our goals is we recently, got involved in the permitting side. We had a different lead on that. One of the big pushes that we are is trying to get you through our process as quickly as possible and as painless as possible. However, just as you guys all are aware, the ordinance has a lot of requirements. So one of the things that we ask you to do is really lean on your agents if you have any. If you don't have an agent, lean on our staff, is to really front load your applications. There's a lot of requirements in there, a lot of plans that we need. If we get those things up front, it makes our job easier, makes your life easier, because then we can just check the box, say they've met all the requirements, and then we can move you through the process and you can move on with that. Those plans that are like the development plans and conditional use permits is a little bit longer process just because we have to go to public hearing, but the land use permits, if you can meet those requirements, meet those standards, then it's easier for us to get through that. One of the things that we're finding is that we are missing some information, so we really encourage you to work with us on the front end. Take advantage of that intake appointment to make sure that you can get all those boxes checked. And so then our planner can work with you as far as fine-tuning and finessing the information just to make sure it meets the ordinance requirements. But that's where we're at, is we're dedicated to trying to get these things, get you through the process and provide you the guidance that you need to do that. So that's really all that I have. But
okay. Questions for Jeff? Oh, I couldn't have guessed. Jay put his hand up first.
Except for Jay.
Archaeological reports required for everything, including greenhouse, unless we have knowledge it's already been studied, or okay.
You want me to answer that, or?
No, you nodded. So
what's that?
Are archaeological reports still mandatory, regardless of whether or not there's no ground disturbance.
So the way that we're approaching that, thanks Jay for that question. The way that we're approaching that, the ordinance does require an archaeological study on that. What we're directing applicants to do is, the baseline is you got to do a study if there hasn't one already been done. However, in the instance that there's historical cultivation on the property or historical ground disturbance, we're asking you to provide that information with your application. So instead of going out, you can either go do a study or you can provide us the information that we need as far as there's historical cultivation on the site, or there's been some disturbance, or this was planted in strawberries and now it's going into cannabis and it was grown at this depth and this area has been disturbed and it's going to stay the same and remain that. Provide that information up front, because then it allows us to give you the direction as far as what level of cultural study you need to do. And it might be, oh, this is historical study, you don't need to do any additional study, and we can check that box. So we're trying to provide that balance on there. Is that helpful?
Sure. One more question. It's a big one, though. It relates to permit compliance. And so, and it kind of ropes in Dennis's office, too. And it has to do with fencing, where the code says you got to have a fence, and but it doesn't. It says if you don't, it says you need to provide ample security. Okay, so I'm getting responses from planners that, you know, where's your fence? And the response might be, we have some fence, but then we have a gully over here, or topography. And how do we resolve that, given that there's a fencing requirement in the code that provides a little bit of flexibility, in my opinion, but then we don't want to pencil the wrong thing on the plans as it relates to law enforcement review of security plans too. So how do you suggest getting some better collaboration on the right fencing and other security? And then the other follow-up to that is, when does the fence need to be installed? I'm hearing that it needs to be installed before you actually get your license or you get a final permit, and a lot of people don't want to necessarily put the money into the ground for new fencing. It could be very expensive on large properties until they actually know they're getting their license or permit. So. Good luck.
So yeah, which part of that question do you want me to start with first? So if I can repeat the question, I think there's like almost three parts to that question. One is the planning department and our requirements. So when you look at the ordinance, there's this fencing, there's a screening, and then there's a landscape. And one of the directions that we're giving to staff is you need to look at that whole picture and not look at everything compartmentalized. So you look at the whole picture, there's fencing, there's a wall, there's some landscaping component, and altogether that might satisfy some of those requirements. So for the planning side is to look at, okay, where on neighborhood compatibility, what needs to be screened? Is it from a public viewpoint? Where's it at? Is there existing vegetation that can be used as far as the landscaping? So that's one of the misnomers that's out there is, oh, it's ag, I don't need to do a landscaping plan. The way the ordinance reads, you have to do a landscaping plan, but what staff is, the direction we're giving staff is to work with the applicants and say, if you're in a remote rural area and you can't be seen from a public viewpoint and there's existing vegetation out there, then that could be part of your landscaping plan in addition to your wall and your screening and all that type of stuff. So that's the information that we need to hear from you, is site-specific conditions and areas, so to help staff check that box and say, okay, they've met the landscaping, the fencing, and the screening thing. The other questions that you answered is, okay, how is the interaction with the security? If I have a gully or if I'm on a bluff top, does that equal the security plan? And I don't have an answer for you on that. I know you've asked that before. But what we're moving towards, are you ready to answer that today? Yeah.
All right. Hey,
so
okay.
I don't want to speak for the sheriff's office. So
it's actually one of the things that we recognize that's a problem during the process. So obviously we threw this out there, say, hey, let's see how it works, and we'll tweak it, make it work as it goes. One of the questions we get, especially Mr. Higgins, he hit us pretty good about it too, is everything's dealt with individually. And as we see it, there's no cookie cutter answer to any of these things. So our hope is to get in earlier in the process, which I'm going to have a meeting with P&D very shortly over this, to develop the best way to do that for you guys. Because if we can identify it early on and get it wrapped in, then that alleviates a lot of headache coming in afterwards trying to fix amendments, changes to the plans, and so on and so forth. So I think if we can carve out time on each application when it's submitted, we'll be able to look at it and say, yeah, that looks good, or no, we want this. and that gives you guys ample time to do that as well, whether it's add it to the plan process or to ask more questions or whatever it is. Ultimately, our goal is to do something that's going to work for everybody. And we understand that everybody has a very unique situation, especially some of these places where the growth is taking place. There's topography issues, there's just a lot of different issues, and they're all just different and unique. So our hope is to do that so we can get that settled early on so you guys can move forward with the process without much delay, hopefully.
And so my recommendation, if I can jump in or tailgate that, or I don't know the right word on that one, is when you're submitting your application to us, and we will work with the Sheriff's Office on reviewing that, provide that in your project description or your documentation saying, here's our fencing and screening security plan, and it's going to consist of, there's a topography issue, and that's going to help alleviate the security issue. And then we can evaluate that, and we'll either concur or not, say, no, go ahead and put a fence on your bluff or down your bluff, theoretically. But anyway.
Good. Okay, so we'll work on that internally. Let me go to North County real quick, and then I'll come back to Lisa. So, please, your question for North County.
I just wanted to find out, North County, I'm Rebecca. Okay, for the initial intake meeting, what exactly do we need to bring down with us to submit our application and pay our fees? Because I understand you don't need everything. So what are the minimum requirements you want us to bring in when we submit our application?
Yeah, thank you for that question. So the question, I'll just repeat it. What do you have to bring for your intake appointment? In my opinion, bring everything that's required in the ordinance as far as what staff needs. And the reason why I say that is, and I'm being very selfish, the more information you give us at the front end, I'm looking at a blank screen. The more information you give us at the front end, it helps us do that analysis. So if you don't bring something to that intake appointment, then you run the risk of either it doesn't get accepted or you're going to get a letter back saying you didn't provide this information, so go ahead and provide it.
Okay, well, just to clarify, I know you don't need all the reports like the archaeological, the endangered species and that sort of thing. So, and you also don't need the fish and game, correct?
So thank you. The question is what reports is, and so again, I'm sounding like a broken record. It's site specific. So if you have those issues on your property, submit that report because that helps us. So if you don't submit it, you're going to get a letter back saying there's some biological issue. Do you have a study that supports that? And if you don't, then we're going to say give us that study and bring it back. So we're not trying to make it be an obstacle to you. We're really trying to help you get through the process. And so the more you give us, the easier it is for us to do that analysis and get it out.
Okay.
Hi. Yeah, thanks. So both previous questions are along the same line. I wanted to ask further about the fencing requirements, and I believe it's Officer Frank? Yeah, thank you. I saw you out in Solving. In any event, having more departmental coordination would be very helpful. I had an experience just recently where I was told I can landscape it, screen it, but it doesn't matter from the planning department's perspective. When we go to get our business license, then we'll have to deal with security. And it's like, well, wait a minute. Like you just said, I don't want to plan something at this level and then get kicked upstairs and have to redo it, because then we get into this circular. Yeah, okay, perfect. So I did want to suggest, again, reaching out to us land use consultants for clarity, and also maybe sharing information of experiences that could be helpful. Any workshops that can be done, having consultations individually with the sheriff department to know how to plan these things would be great. And in terms of the intake process, I guess I had an experience with that as well, and understand we got to have all of our I's crossed and T's dotted. If you caught that, you're following me. Good. So that kind of speaks to the completeness, incompleteness, which isn't really relevant in the land use permit realm. Do you have some sort of an official deemed complete, or when CEQA gets turned on, a part of the process for your provisional? How is that playing out? in terms of having a complete application so you can get kicked on to secret review?
So I'll just answer that generally. So if you're applying for a land use permit and you meet all the standards, we did a program EIR that covers most of those activities, and so that you can move on in the process, and it makes it, that's what I've been talking about, it makes it easier to get our review completed. What we're finding is, even with the land use permits, we're missing some of those items that are required by ordinance, and so it's hard for us to say you've met all the standards if we don't have all the information. So it's not really a completeness, incompleteness thing, it's did you meet all the standards? So it's like if you submit a building permit and you don't have an electrical plan with it, it's the same thing that's happening here, is we need all those pieces so we can check the boxes and say, you've met all the standards by ordinance, therefore we can issue the permit.
And I'll just kind of add in this discussion about CEQA underway is the technical statutory language from the state. And I don't want to be too cute by half on any of this. I don't think any of us do, and run the risk of audits that might involve the review of our records. I'm giving Kevin no ideas here. That we want to make sure that we're doing absolutely as much as possible. And I think this is related to the women's question, Rebecca's question up in North County, which is, bring all of your stuff, bring it all. And I think that way you've got something in there for every single element of the required plans, as well as the permit application and the money. So that's really what we talked about with the state, was really about when we've put it on that list because we've accepted that application. Let's not talk about completeness. Let's talk about whether the application is accepted and the fees paid. That's our beginning point. So if you don't have something in there, you run the risk of the application not being accepted at intake.
And if I could, Dennis, if I could just include on that, on the CEQA underway, is the way that the program EIR works is that a lot of those mitigation measures or standards got codified in the development standards. So if you can meet those development standards, then you're compliant with CEQA. And so we can do our CEQA compliance under that review. So meet all those development standards, then you're going to be in compliance with CEQA, and we can say you're consistent with that program EIR. And that's a really key point, because that's why we're holding the line on those development standards, because that's helping us satisfy the CEQA compliance aspect of it. There's going to be some anomalies there on site-specific things, but generally meet those development standards, and we're going to be able to check both those boxes.
So, not to go down the repeated question path, but back to fencing, because I'm still confused on requirements from different agencies while I'm setting up my plan and submitting plan, the time and energy going into it to be changing throughout the process later on down the line after communicating with property owners, taking the time and energy to do it. So one of the quick question maybe to help me is, and maybe it can come from the sheriff's standpoint, if it is, the fencing is based around a secure premises, does that mean if your property side is greater than wherever you're cultivating in, if you create a secure premises within that parcel, is that what we're looking for to create for our application process?
Good question. There you go.
So that's what kind of created the need to come up with some kind of collaborative effort between us and P&D early on, because what we think is going to work doesn't necessarily match up with the ordinances. So what we're finding is, I want you to do A, B, and C, but A and B are good, but C is totally outside the realm of the county ordinance, and it violates the section, right? So my recommendation is, you guys are all artists here, right? I mean, you're in the industry, you're putting out your unique blend of business opportunities and stuff. When you come up and you develop your plan, you know what you're going to use and where you're going to use it. Base your plan on that. There's two parts to the, oh man, I really don't want to go into P&D stuff.
Don't do it.
The section really just requires you cultivation, right? The cultivated areas need to be secure. That could be the entire perimeter, property perimeter, or that could be just the area where the cultivation is taking place. And then the cultivations, by definition, is anything to do with cannabis, period. In simplest terms, of course. Not my terms, not the sections, because it's a lot more than that. But with that in mind, then you do what's beneficial for you and what's going to work best for you. If you have 100 acres, maybe it's easier for you to fence in 1 or 2 acres of that where your cultivation activity takes place, instead of the whole perimeter of the 100 acres. So that's something that we need you guys to do. Throw out your idea, throw out your artistic touch to that. Tell us what you're going to do. We'll look at it and say, okay, that works for us. P&D will say, yeah, and that works for us too, and then we're happy. Or we'll say, that doesn't work, we need to do this instead. It gets vetted by P&D, and then you'll know exactly what you need to do. So that's what kind of the goal is, and that's what we hope to do, which hopefully answers your question.
Yes, except for there's still that looseness of at the end after I've gone through state.
So after that, it's a ministerial permit. Yeah, it's still I mean, for the most part, we've got ministerial permits. So you do what Frank says, and you do what P&D says, done. Okay, right? And so I just want to keep it real simple. I want to keep this moving because we still got some more stuff. I want to check with North County. Is there any other questions up north before I go to one more down here?
We're good, thank you.
Oh, good. Okay, thanks. All right, so Lisa will have one last question, and then we'll keep moving.
Just, sorry, just one more question regarding fencing. Because there's 2 sections of the ordinance. There's one that talks about security fencing, and then the other section is landscape screening. We propose to put a artistic representation across our security fence.
So I know this one you're talking about.
Yeah.
Let's talk about that offline.
Okay, thank you.
That's more of a specific question.
Okay,
But
thanks. All right. Anything else that's going to, like, the end of the world will occur? Yes. Here, wait. I know you're loud.
I'm loud. What I need to know is the difference in the requirements between a conditional use permit and a land use permit. So far, all I've heard you talk about is land use permits, which are a whole lot easier to get. And
So what, are there additional?
is there new information changes in why I have to have a conditional use permit and my neighbor can?
Yeah.
Yeah, thank you. So the question is, what's the difference between a land use permit and a conditional use permit? And I'm just going to make this super simple. The ordinance identifies the level of permitting that you're required to. So certain activities or uses are designated in the ordinance as a conditional use permit. And what that means is it just has a level of discretion applied to it, and you have to go to a public hearing, which is like the planning commission, where they can add conditions of approval on it. So hence, it's a conditional use permit. So other activities or uses in the ordinance are identified as a land use permit, which is a lower level staff, director level permit, which if you meet those standards, then you're rocking and rolling. If you have a conditional use permit or development plan, it's just a more intense activity or use, and there's some more discretion afforded to the county to review that, and it has to go to a public hearing for approval.
And currently, the board is not considering any changes to what requires a CUP and what requires an LUP. That has not changed since a year ago. That's correct. They are looking at doing some different zoning in Ag 1 in the inland portion, but it would probably be more like going from requiring a land use permit to not being able to cultivate there at all. More of a prohibition. That's the only thing the board's asked the staff to consider. So but not anything that's switching between LUP and CUP. And there always is going to be a line where there's an LUP required, and then the next neighbor over is going to have a CUP, is going to have the opposite kind of zoning. You're always going to have a neighbor where somebody's going to abut somebody. Okay? So, no. No CUPs have been issued. All right, last question.
The timing of the planning department, long range, getting back into some of the ordinance issues that were discussed by the board. Is there any timeline on that?
Maybe Jeff, talk about when you're bringing the long-range planning work plan to the board, because there's a policy decision they have to make about whether to do it now or do it later, right? So.
Okay, and I'll generally answer that. As of right now, we don't have any hard and fast dates of when those changes would happen. In the next month, we'll be taking the work program early April, getting direction from the board of supervisors, what their priorities are and what they wanted us to work on. So depending on how that direction we get from the board, we'll have a better time frame on when those ordinance changes will be brought back.
So next up, I want to bring Stephen Yee from our office, who's working on the licensing stuff. So Stephen.
Good afternoon, guys. So after you've navigated your way through the permitting process, you've paid your $100 and spent the 2 weeks to obtain that land use permit. Okay, that was an attempt at humor. You would come to see me. So I coordinate the business license team, which is made up of about 6 county departments, which will be reviewing a bunch of different criteria and requirements that were established in the business license ordinance. So I encourage you all, if you have not already, obviously apply for your permit, and I would encourage you to also begin filling out your application and assembling all the documentation that is required for the business license. Although we don't officially start processing and reviewing the business license and the documentation until the land use entitlement permit is issued, it is a process. There are a lot of hoops to jump through, so I would really recommend gathering up all that documentation. The application is currently available on our Cannabis website. It's currently a manual form, and you can submit it. You can hand deliver it, you can mail it, or you can submit online. But in the next 3 weeks, we hope to be establishing or going live with this public-facing portal, and it's done through Acela, the same company that does the state's licensing program. So for the business license process, we established a 6-week target timeline. But of course, there's so many variables involved. It could potentially be shorter than 6 weeks. It could potentially be 4 weeks, or it could extend out depending on what the issues are that our reviewing departments would find. So if there's well issues, septic issues, that could really potentially extend the timeline out several months. Currently, we have 4 applications in the process. I believe those are the 4 applications. Let me back up. So there were 4 permits that were issued, and those 4 operators have submitted business license applications. So anyways, again, I just encourage you to start reviewing the requirements, fill out the application, and then also submit any documentation.
Okay. So questions for Stephen on business license?
With the business license process, obviously everybody right now has temporary licenses. They're going to be getting provisionals potentially before they actually have their CUPs. Going forward with new applicants in the future, will they have to get the business license before the county is going to grant permission for the state licensing, like for annual licenses in the future?
Yes.
Yeah. Okay.
Yes, we will require in the future, when there's no more provisionals, you'll have to go through land use permitting first, business licensing second, then the state.
Can we submit for our business license concurrent with our land use permit?
You may submit. We won't begin processing or reviewing or doing site inspections until that land use permit is issued.
Yes. Yeah. Okay. North County, any questions on this one? On business licenses?
No, thank you.
Hey, what's your name, by the way? I just want to say hi and thank you for doing that.
My name is Rob Traylor. Thank you for hosting this.
All right. Oh, thank you very much. All right, here we go. Business license.
Actually, kind of in a nutshell, between county and back over with Kevin in CDFA, is anything other than local authorization on your side would hang up a license being either an actual annual versus a provisional, meaning like licensing through whatever department, security plan, fencing, anything? Is it just local authorization on CEQA that you're looking for?
The agreement we have and what we got direction from our Board of Supervisors from 2 weeks ago was to say that if you've got your land use permit accepted in the process, okay, or a permit issued and you've applied with Stephen for a business license, and you have the temp licenses, which is what CDFA requires, that you'll be on the list, and you've submitted a complete, not complete, what's the other word I want to use? accepted. You've had an accepted application. Thanks, Bobby. An accepted application. You paid your fees. So that list is what's getting scanned and sent up to Kevin. Well, not to Kevin, but to Cal Cannabis. And at that point, then there should be nothing else that holds it up. Okay. You've got to fill out a permit application through planning and development. Planning and development. Step 1, planning and development. Step 2, Stephen Yee. Step 3, CDFA. Okay? All right? Good. Any other questions for Stephen? Good. Thanks, Stephen. I do want to bring up Frank just to talk about enforcement. Guy's been kind of busy lately, so I just want to give him a chance to talk a little bit about what we're doing about the unlicensed folks.
So as you guys know, we have been doing enforcement. We've been trying to keep it pretty heavy, but there's a lot of work that goes into it. What we're starting to find is, like everything else, people adapt to the way we do things, so we have to adapt and change as well. But one thing that really stays consistent is the community and the people that reach out to us and that you guys are all here trying to figure out the rules. So kind of goes more into the sense of, if you guys are going to put in all the hard work, they have to put in all the hard work too, and if they're not going to, then we're going to go see if we can find them and root them out so we can add more legitimacy to the business. So I think to date, we are at 22, 24 enforcement actions. I think we're, as far as volume, I think we're upwards almost to about 600,000 plants that we've eradicated, thousands of pounds of processed flour that we've seized, and a whole lot of other things that we've destroyed. So enforcement's been really good. The DA's office has been very supportive, so those cases are being looked at. They're being looked at individually. Again, like all other things that we do, nothing's cookie cutter. Everything's based on the set of circumstances. So we have a lot more planned. We're just trying to figure out what part of the county we're going to go to next. Just like I said, they're all over the place. Seems like for every one person or one person in the industry that we have that's doing it right, or trying to do it right, we have 2 or 3 that are trying to circumvent it. And what we're trying to do is we're trying to catch the stuff going out the back door. Because as you know, it's the whole intent behind this is to keep it safe. Regulate it so we know what the THC content is, so we know how the flower is being grown, and we know the content of it. That's really what it's all about. But we've been to sites where carbofuran's present and all these other things that are really dangerous to people. And that's what's being packaged, and that's what's being sent out the back door. So thank you for all the help that we have had, and I'd like to thank you guys for all the help that we will have, because again, you guys are in it with us, and we're in it with you. So if you guys know of any bad actors, bad players, problems, please let us know. We'd like to listen to what you have to say. So we're a small group of folks, but we get a lot of work done. We're not afraid of it. And we're also here to help you guys out. And again, I'd like to ask you guys for help too. So if you do have those tips, the county has a website tip line set up, and the Sheriff's Department has one as well. It's Cannabis Tips at sbsheriff.org. Try to keep it as original as possible, as easy to remember. Or you just call me. You call the Sheriff's main line, or I can give you an office number if you guys want afterwards. And you can either leave anonymous information, or you can leave as much information as you want to. You guys are experts in the industry, and at some point we're going to reach out to you and ask you for help too, because there are things that we need help figuring it out. We're learning the process. We're learning a lot more than I ever thought I'd know about marijuana a year ago. Even planning and development rules, it's just crazy. So just learning a lot of stuff, but I need to know what's important for you guys too, and whatever you guys are willing to share with us, that'd be really awesome. So does anybody have any questions about enforcement or any of that stuff? Yes, sir.
I just want to know, what do we need to do to make sure we're not on your list while we're compiling all the information we need to submit for our land use permits and things like that?
Just stay up front, stay in the process, stay engaged. If something's broken, let us know. Like Mr. Higgins, he really showed me that there was a problem that we had to fix on our side, my side. And that was kind of evident with things that we're doing, so we fixed that. But if you're making an honest effort and you're trying to get everything lined up and you're going through the process and you're in the application process, and if there's delays built in there and they're no fault of your own, we look at that stuff, and maybe we'll move to someone else or something else.
Can I add one thing?
Sure.
Don't cut corners. Don't cut corners. That's the corollary to be straight with us, don't cut corners. The major things where lately, it's been people that have cut corners. They've tried to plant too soon. And I know everybody's going to get a bug to get something in the ground in March. I get it. But don't do it if you're not operating under a temp license, if you're not operating under a provisional license. If you think, oh, I should have my permit, or I should have my land use permit or my business license any day, and you plant, don't do it. Did I say don't do it? Okay. Yeah. Yeah.
Russian
Hey,
roulette.
any questions up in Santa Maria for Lieutenant Vasquez?
No, thank you.
Oh, okay. Maybe we need to come up with hand signs like baseball. So thanks very much, Frank. And I just want to thank the team. This has been a really fun. It's been fun. It really has been a great experience actually for our county to bring so many departments together to work on this process. The other side is you guys have kind of made it fun in the sense that you're really kind of challenging us to learn how to take an industry that has frankly been clandestine and hidden for years and years and years, and how do we bring it into the light, right? So and a lot of that responsibility goes to you. So and so it might be really. I just want to keep the partnership going, keep the dialogue going. So. Oh, hey, in Santa Maria, how many folders do you need?
By folders, what do you mean?
I'm sorry. Yeah, you didn't see where I walked. Yeah.
Oh.
So this was from Francisco from EDD, the EDD folders with all the information about taxes, withholding taxes.
10.
10.
Please.
Thank you very much. All right. So with that, we will do another one of these again, but know that you've got some deadlines coming up, right? You've got some deadlines. So your temp licenses are going to start expiring, and you can't have plants in the ground with expired temp licenses and no provisional license. What do you have to have in order to get a provisional license? A land use application that's been accepted by P&D and your fees have been paid, right? Or your CUP application. Thank you for letting me be specific.
I held my question, but I'm circling back on the LSA. Can you please provide clarity in terms of what the CDFA will accept for the provisional license?
So what I'll say is what I've seen from Fish and Wildlife is they have a letter that'll say it's in process. Now, whether CDFA, they still have a policy choice about whether they're going to accept that for the provisional license. That's outside of my hands. That's CDFA's. But they do have a form letter that they will generate that says it's in process. I don't know whether they'll accept that or not. You're welcome to hang out for the poetry contest that's coming up in an hour or half an hour, I think. Otherwise, thank you very much, and we'll be back in touch. We will send out the materials from today so you have them in your email box. Thank you.
Sir, where will those packets be available to be picked up?
Santa Maria, I'm going to send them to the whole group electronically. If you got an invitation from me or from our office, from the CEO's office, you will get one in the email with all of the handouts. If you didn't,
perfect. Thank you so much.
Come write to ceo@countyofsb.org, and we'll make sure we get them to you.
Great. Thank you.
Thank you.